and thank you for taking the time to join us today. I am Joanna Thurston, a partner in the chemical team at Withers & Rogers. I'm speaking to you today as I work extensively with university clients both in the UK and abroad, and I have a little bit of in-house experience in tech transfer. The focus of today's presentation, which forms part of a three-part series, will be how to make use of your intellectual property. So, let's get down to the business of discussing how to make money from your intellectual property. We will often talk about concepts like exploitation and commercialization, but what does that look like? Firstly, it's worth taking a look at how the rights discussed earlier, in particular patents, designs and trademarks, fit together in a product development process. Initially, as shown in the box on the left, we define a need, a problem that needs to be solved. There's always a problem that needs to be solved. That's why you develop new products. And then we figure out a way to solve it. So far, so good. That's how invention arises. It's how products are developed. At the end of this process, we have a prototype. And imagine an ugly box with wires hanging out of it. It's not aesthetically pleasing at all. And so in the second stage of product development, the middle box, we work on the design. This may involve market research to help plan the look of a product and create something desirable. And once you have the aesthetics planned, you might file a design registration. Finally, we need to find a name for our product, and we generally trademark that. This is the final stage before determining the route to market. For instance, the route to market could be licensing, sale of IP, franchising, direct manufacture, others. We also need to consider enforcement issues, and we discuss both enforcement and exploitation routes in the following slides. So what are the key uses of IP? Each of these is discussed in more detail later in the presentation. The first use, and possibly the most obvious one, is the prevention of competitors from entering the market with similar products. This is generally known as the fortress model. Alternatively, you can look to prevent your competitors from entering the market with competing but dissimilar products, and this strategy is often termed offensive registration. You can use your IP to generate royalties from license deals. You can use your IP to support spin-out ventures, for instance by providing credibility for investment and funding purposes. You can sell it, like any other property, for a fee to provide direct revenue. It can generate inventor prestige, which in turn can assist in the generation of grant funding for academia. And there are tax incentives available through the so-called patent box system. Interestingly here, whilst they're not necessarily mutually exclusive, each of the objectives above requires a different exploitation strategy. To start with the fortress model, you'll remember that patents and other IP rights are negative rights. They prevent others from using an idea, design, trademark. In the fortress model, you build a patent portfolio to protect your products and defend your market share. This prevents competitors from copying and marketing your products or launching very similar products, or at least not marketing them without a license, giving you the choice either to generate revenue or refuse the license. What this model doesn't do is prevent the sale of competing products that are of different design. So, by way of example, you're unlikely to be able to stop the sale of a competing laser printer when you've developed an inkjet printer, or an OLED TV where your patent covers an LED system. These dissimilar products can still erode your market share even though they don't infringe the patent. And that is where, and we'll come on to this later, the offensive patenting model can be of interest. But, for now, to stay with the fortress model, an excellent example of this is shown in the high-profile Dyson Hoover bagless vacuum cleaner battle. In 1991, Hoover were the market leaders in the UK, with 25% of the market. Dyson were just a small startup company developing their first product. Just 10 years later, Dyson held a huge 50% of the market share, and they'd eroded Hoover's market share to just 10%. Now, one reason for this was that Hoover couldn't stop Dyson selling their products because Dyson's technology was so different from what had gone before. Hoover just didn't have any IP that covered it. In some senses, Dyson had created a laser printer in an era of inkjet printers. Bringing things forward to 2010, and this is still roughly true now, Dyson has a 40% market share, numerous products in other fields, and 190 million a year of operating profits. There's no question that Dyson's success is down to more than IP, but IP has been a crucial element of that success. So what was Dyson's journey? Well, in 1979, Dyson filed their first patent application, but it wasn't until 14 years later, and over 5,000 prototype iterations, that they launched the DC-01, which was their first product, as shown here. One of the things that this shows is that providing you have a concept, the bagless vacuum cleaner, you can protect future products even if you don't know what they are. A patent application was filed to the concept, but it took 14 years to actually get a product built to that concept. It also shows that even in relatively simple fields such as engineering, it takes time to develop a product, and so you have to commit to the IP and often incur significant costs before product launch. So Dyson launched the DC-01 in 1993, and 5 years later, as discussed, they held 50% of the market share. Not surprisingly, Hoover wanted to claim their part of the market back. So in 1999, Hoover launched the Triple Vortex Cleaner. The small problem was, it infringed Dyson's original patent, which was still in force but about to expire at the end of its 20-year period. As you can see from the slide, the High Court found Hoover guilty of patent infringement, granted an injunction to prevent further sale, and awarded £4 million worth of damages. The key point here is that Dyson recognised that the cyclone technology he was investigating at the end of the 70s was the thing that would make his products competitive. In fact, he created a whole new market. The patent applications he filed helped him to keep competitors out of the market for a number of years. In addition, the high-profile nature of this case created the reputation that Dyson would enforce their patents, enhancing the deterrent effect of the rest of the portfolio. However, as we've already discussed, patents aren't the whole story. Dyson have also made use of registered designs and trademarks. As the appearance of the DC-01 is so distinctive, it was protected by registered designs to deter knockoff copies. The trademark has been registered to prevent unauthorised use of the Dyson brand, thereby preventing others from piggybacking on the reputation that Dyson has invested so much time and money in generating. In addition, as Dyson expanded their product range, they've also expanded their patent portfolio to over 5,000 patent applications, continuing investment in IP protection to maintain their competitive edge. And they are still not frightened to enforce their rights. In 2001, 12 years after that initial tussle with Hoover, Dyson made use of their design registrations to prevent VAX from copying their DC-02 vacuum cleaner, as you can see from the slide. Turning to the concept of offensive registration, we've discussed that generally laser printers don't infringe patents to inkjet printers, yet they can erode market share. Offensive patenting models might help to mitigate this. They involve monitoring your competitors' product developments and seeking to second-guess where they'll go next, then patent that next step. This can prevent further development of the third-party product, or force them to incur the cost of significant product redesign, or take a license from you. As you can imagine, this is an aggressive and expensive strategy. Turning to the licensing model. Licenses are essentially contracts, and as such can be written to cover almost any scenario where one party wishes to permit another party to make use of their IP. They're often granted by sector or by locality. Licenses are often valuable where the patent owner doesn't have the resources to exploit the market directly. A license allows income generation in such markets. So, for instance, a license granted by locality might be a license granted by a European company to a US company. The European company doesn't operate in the US, and the US company is held by license not to compete in Europe. That way the European company can get the revenue stream from the very profitable market of the US without having to put distribution networks in place or local sites. A license granted by sector could be a license where the patentee holds, say, a patent for a waterproof fabric, and the patentee's core business is tent manufacture. They might license the patent to a third party who wishes to make waterproof clothing. As our tent manufacturer doesn't have the capability to make lighter weight fabrics, they can't exploit that part of the market, even though that part of the market, the lighter weight fabrics, falls within the scope of the patent. Licenses often also include within them a sharing of know-how to enable the licensee to learn the hands-on skills needed in order to use the invention. This combination of both registered IP, for instance the patents, and the know-how tends to provide for higher royalty rates than where the patent or design is licensed with no associated implementation support. ARM are a company built entirely on licensing. You may or may not have heard of ARM. They don't make anything. They design chip architectures for computer processors, the very chip architectures that are used on almost every mobile phone chip. And they make £1 billion a year, and they were recently sold to SoftBank for $24 billion. Not bad. So, how can you make money without making anything? You can come up with ideas and license them. In this figure, the partner, a chip manufacturer, licenses architecture and makes chips, which are then sold to the OEM, a mobile phone company. This architecture license from ARM to their partner is in return for royalties. Further, the partner is encouraged to source their architectures from ARM, as the OEM often requests this. This is as a result of ARM's strong reputation in the marketplace. So at the beginning, when ARM was set up, what IP was in place? Initially, believe it or not, they had no registered IP. The company started with a proof of concept for a new RISC chip architecture for Acorn Archimedes, but no patents in place. There were just 12 engineers in a barn, literally, with no independent customers and a product that wasn't ready for the commercial market. Initially, it was know-how that they licensed to an investor, VLSI Technology, and that all happened at the end of 1990. This established a reputation for the architecture in an end product and enabled ARM to fund R&D to develop improvements and build a patent portfolio to protect their innovation. And as you can see from the numbers on this slide, ARM are now incredibly successful. A further use of IP is to support spin-out ventures. The IP can provide credibility for investment and for funding purposes. And it can be used in the traditional way, namely to protect the market share of the spin-out company or to generate licensing revenue. When using university IP to support a spin-out, it's important to ensure that the spin-out has full access to the university IP. Now this could be licensed to the spin-out and would generally be on an exclusive basis for at least the initial period. This setup benefits the university as they need to ensure that the IP they generate is used. But if the spin-out folds, and we have to accept that many do, the licensing provides an exit route for the IP because it's still owned by the university, and so they can relicense it elsewhere. This is significantly less easy to do if the IP has been sold to the spin-out company. However, the license between the university and the spin-out could include clauses to assign, for instance, at a given commercial milestone, which benefits the spin-out as it's attractive to investors. As you might expect, licenses may be associated with other agreements, for instance, access to laboratories or equipment, consultancy, or further research collaboration. An example taken from our client base is the spin-out NTEC. NTEC came up with a novel method and machine for grading the purity of aluminium. The product is a machine which works by sucking molten aluminium through a filter and assessing the time taken. The amount of impurities in the aluminium can be determined by the time taken to pass through the filter. This method vastly increases the speed of grading by removing the need to have samples sent for analysis. In essence, the grading is done on the spot. Our part in this was that we obtained a patent for the machine and a patent for the filter. The filters are consumed in the process and so must be replaced between each use. NTEC then licensed the technology to two different companies, one making the machines and one making the filters. This gave NTEC two revenue streams, which is a very nice example of a licensing model in use. Theranos weren't really a spin-out, but the idea for the company was developed by Elizabeth Holmes while she was studying at Stanford. She then dropped out to build the company. Theranos created a rapid diagnosis and treatment device, a wearable patch, to administer drugs and monitor when the next dose was needed. Elizabeth Holmes filed her first patent application in August 2005 and ultimately became the youngest self-made female billionaire on the Forbes 400 list. As you can see from the slide, many more patent applications followed, including one to the real-time detection of influenza. Given the huge impact that this could have, this attracted over $400 million of investment funding in the period between filing the application in 2007 and 2014. And then it all went very, very wrong. It became apparent that the test data was being falsified. This destroyed the company and Elizabeth's credibility. Elizabeth will stand trial for her part in this, but somehow, in some senses, she's still coming up roses. She sold the rights to her story, and Jennifer Lawrence has been cast to play Elizabeth in the movie. The working title for the movie is Bad Blood. It will be very interesting to see what Elizabeth's future holds. The next application of intellectual property is its sale. The assignment of IP is analogous to the sale of any property, be it a house or a car. And the sale of any goods are generally in turn for direct revenue. IP is no different. The sale might occur where a company is diversifying and no longer has an interest in patents filed in a field that they're no longer working in. Another example of the sale of IP might be from the university to a spin-out, as already mentioned, after a period of licensing, or from one university to another where a lead academic moves to a new position. Turning to tax relief, it's possible for a company to claim tax relief on corporation tax, reducing it from 19% at the time of recording this to 10%. It applies to any profits derived from patented products, providing the patent has been granted. And so it's in our interest to get any patent application filed for these purposes to grant quickly. However, to allow for the time taken to file an application and take it to grant, it's possible to backdate the tax claim by up to 6 years. Other qualifying criteria include that the benefit is available to UK companies only. However, the patent owner and an exclusive licensee can make a claim. One huge benefit of the system is that for complex products, the benefit applies to profit on the whole product. So for instance, if a car manufacturer obtained a patent to a lever in the wing mirror of a car, they can claim relief on the products derived from the whole car. Because what we're trying to achieve with a patent box patent is totally different from patents filed to obtain a monopoly. The way that we write the patent application is also very, very different. Unlike patents filed to obtain a monopoly, patent box patents are generally narrow, just protecting the product so they can grant quickly and allow us to claim the tax back quickly, and that the grant process doesn't cost very much. We want that to be as inexpensive as possible. And we can do this because we don't need a wide monopoly to get the tax relief. We just need to protect the commercial product. So an example of the benefits of patent box tax relief is the case of Gecko Headgear. Gecko are a client of ours. They're based in Butte. They had a patent granted a number of years ago, which, when the patent box system was created, they realised they could use to claim tax relief. They have been saving large sums of corporation tax every year as a result. As the original patent was about to expire, they have recently changed their design slightly so that we can file a new patent application to enable them to continue to make these savings after the expiry of the original patent. We have other deliberately anonymised examples. So, for instance, we have a client who made £600,000 in 2019 and £2.7 million in 2018 from Patent Box. We also know of and work with numerous mid-sized UK companies that are saving in the region of £20,000 to £50,000 a year through this system. The final use for IP that I'd like to speak about would be inventor prestige. It can be a large personal motivator for some inventors, and it can assist in the generation of grant funding in academic environments. It also ticks some of the impact boxes. And lastly, where inventors are students, it can be good for their CV. I've filed applications in the past for universities purely to assist undergraduates in getting recognition for their ideas, primarily to support their CV. So, we've not discussed open source, and it is a relevant and commonly used approach to sharing your ideas. In essence, the open source model is giving your IP away in return for a royalty-free license. But in doing so, can you keep control? Well, yes. You can use your rights to control who uses the idea and what they do with it, even if license fees are not directly levied. You can also stop third parties protecting the idea by filing a patent application, as the patent application publishes after 18 months. Another question, can you still make money through open source? Yes, if you want to. Google apps are open source, but yet they're revenue generating as they strengthen the Google brand as a whole, resulting in an increase in advertising revenue and in the amount that can be charged for instance, the AdWords service. We're also often asked, is it only for software? Well, no. The image on the right here is of shipping containers. Shipping containers were invented by Malcolm McLean. They revolutionized the maritime industry, as discussed in the next slide. Malcolm McLean patented the idea of a uniform shipping container and then issued a royalty-free license to the ISO to encourage the standardization of the technology. The new containers were strong, uniform, theft-proof, and could be loaded and unloaded in a fraction of the time of the jumble of shapes and sizes of containers that could previously be found on any ship, reducing the cost of loading and unloading container ships by 90%. McLean realised that the standardisation was key to the success of the idea. By teaming up with the ISO, anyone with the correct accreditation could use the idea royalty-free. However, anyone working within the scope of the patent, and so infringing the patent, outside the accreditation, would need to pay for a licence. In this way, he encouraged conformity and controlled the market, causing a revolution in the transport industry. So thank you. We very much appreciate your attention today. If you have any questions, please email the admin email address on this slide, and your email will be forwarded to someone who can help.